So you formed an LLC to protect yourself. Smart move. But there's one thing that you might have already signed that can completely obliterate all of the protection you think you're getting from your LLC, and you might not even know it. Today, we're talking about a clause that's included in many contracts that renders the protection of an LLC, corporation, or partnership completely irrelevant. They're very common in the business world, and lots of entrepreneurs sign them without even knowing it. In fact, there's a decent chance that you've already signed one of these without even realizing what you were signing because they're so common. They're especially common in real estate. Today's topic is the personal guarantee. Now, a lot of people think about this as piercing the corporate veil. It's closely related, but it's not quite the same thing. In today's video, we're going to talk about personal guarantees, what they are, why they're so common, what's the difference between a personal guarantee and piercing the corporate veil, and then we're going to read through a sample personal guarantee so that you can recognize one of these. Last but not least, we're going to talk about what you might be able to do if you've already signed one of these without noting it. First of all, what is a personal guarantee? A personal guarantee is either a separate contract or a clause in an agreement that says, in effect, hey, if the party to this agreement, the LLC, my son, my daughter, my friend, if this party to that contract doesn't pay the money that they're supposed to pay under the contract, I promise that I will pay it. Pretty straightforward concept, has some really big consequences. If you sign a personal guarantee for your LLC, for your corporation, for your limited partnership, in your personal capacity, that means that all of the liability protection that you got by having that LLC, corporation, partnership, if your LLC, partnership, or corporation goes under, that liability protection is null and void because the creditor can simply invoke the personal guarantee and come after you personally. To be clear, there are some really good reasons why we use personal guarantees in the business world. Let's say I'm renting an apartment to somebody. They've never had an apartment before. They don't have credit. They don't have previous rental. They don't have anything. I don't know who this person is. I have no indication that they're going to be able to afford the apartment that I'm going to rent them. So we put mom and dad on a personal guarantee. Mom and dad have a billion years of credit history, paying their debts. We have rentals. They own a house, blah, blah, blah. I know that if Junior defaults on his apartment and disappears, I can go knock on mom and dad's door and they're going to pay me. That's a really good case for a personal guarantee, and you frequently see these in like college towns, for example, where college students are renting apartments. They're judgment proof. They're poor. They have no money. Mom and dad are not. There's a lot of other reasons why you might have a personal guarantee. If I'm representing a landlord, someone shows up with their LLC, they want to sign a rental for a commercial lease that normally my client, the landlord, would require a 10-year lease and all kinds of fancy terms and blah, blah, blah. The LLC says, great, sign me up. I'm judgment proof. I have $0. Doesn't even matter if I default on the lease because you can sue me and your judgment's not going to be worth the paper that it's printed on. I'll sign a 500-year lease. I don't even care. In that situation, my client, the landlord, I'm going to advise them to get a personal guarantee from the owner of the LLC, because otherwise it doesn't matter whether you have a 10-year lease or a 1-year lease or a 2-day lease, you're not going to be able to get any money out of that LLC. So these are very common in the real estate context for some very good reasons. On the flip side, if you were the owner of that LLC and you're being asked to give a personal guarantee, you should be under no illusions of the effect of that personal guarantee. You are in effect waiving the protection of your LLC, at least with regards to this particular landlord. Your LLC may still protect you with regards to the printer salesman and the pen salesman and the guy who slips and falls, whoever else it may be that becomes creditor. But at least with regards to the landlord, the fact that you executed this personal guarantee means that when and if the LLC defaults, they're coming to you. You'll see personal guarantees in all kinds of contexts, rental cars or cable subscription agreements, or other contexts where there's no real reason why you would need a personal guarantee. Nonetheless, people have seen that these are effective, and so they throw them in there. You can object in a lot of circumstances and negotiate these things out because they are unfriendly and they do defeat the purpose of your LLC. Now, how is this different from piercing the corporate veil? A lot of people ask me about piercing the corporate veil. It's a very common question. It's an interesting bit of legal terminology that has worked its way into the mainstream. Piercing the corporate veil means that you have done a bad thing using your entity, and we're going to look past the entity and we're going to come to you directly for judgment in terms of a lawsuit. Now, there are various laws that have been passed in various states. For example, in Texas, you have to prove fraud and that the owner directly benefited and all sorts of other things. Fundamentally, piercing the corporate veil is not something that you do by signing an agreement like a personal guarantee that says, I agree to stand behind this thing, I agree to backstop this debt. Piercing the corporate veil is something that we do to say, look, you didn't operate your entity correctly, you were bad, you used this entity in a bad way to defraud somebody, use it as your personal piggy bank, or use it in some other way that you're not supposed to. You didn't do the things that you're supposed to do. Therefore, we're going to look behind the entity and come to you personally. That's piercing the corporate veil. Now, for the next topic, we're going to read an actual personal guarantee clause that I pulled from the internet. I'll put that on the screen now. Now, this clause reads, for valuable consideration, the receipt of which is acknowledged, blah, blah, blah. In the event customer fails to pay all or part of its obligations when due under this agreement, guarantor, that's the person signing, agrees to pay in a timely manner all amounts not paid by customer. Guarantor is mom and dad. Customer is the poor college student with no credit history. Guarantor is the owner of the LLC, and customer is the LLC. In addition, blank agrees to pay all reasonable attorney fees. There it is. If they have to sue you, you get to pay their attorneys, and all costs and expense incurred in collecting or compromising any indebtedness of customer guaranteed hereunder, meaning any debt of customer of the LLC or the college student that the personal guarantee applies to. This personal guarantee is in no way conditioned or contingent on any attempt to collect customers' payment obligations. That means they don't have to try to go get a judgment against the LLC or the broke college student. If they know they're broke, they can come straight to you, mom and dad. The obligations of guarantor remain in full force and effect, notwithstanding death or disability. Means you don't get out of the contract. If you happen to go die or become disabled, they're still going to get their money. Now, last but not least, like I said in the very beginning of the video, these terms are very common in the business world. If you've already signed one, what do you do? Well, there's a couple answers to that question. First of all, if you sign one in the context of a commercial lease for like an office space or something like that, you probably don't do anything, because honestly, the odds are that if you go look at 10 other office spaces, probably every single one of them is going to ask you for a personal guarantee because they don't know you. What are your other options? If you've been here for a long time, if it's a lease that you've been in for 5 years and you've established a payment history, you can go to the landlord and say, hey, I've been a good tenant. For our renewal term, I would like the personal guarantee to burn off, meaning when we renew this lease, I would like for you to waive the personal guarantee because now we have a history. Now we have a credit history. You know that I give you that check every month on time. So that's one option that you can negotiate. What are your other options? You can wind up the contract in full. Suppose you signed a personal guarantee for a copy machine. You can finish up your contract, return the copy machine, say, here you go, I'm done with my lease. Whatever your termination provisions are, perhaps you have to give them 30, 60, 90-day notice. You write them a letter, you give them the notice, and then you give them back the copy machine. And then you go find another copy machine company that's not going to make you sign a personal guarantee, and you rent that copy machine. Above all, if you're signing a personal guarantee, you should know what that means. You should know what rights you're giving away. In a lot of circumstances, this is not something that you're going to get out of. In some circumstances, it is. In some circumstances, it's something you can negotiate away. In some circumstances, it's something that you can say, hey, we're going to sign a 5-year contract. How about after 18 months, the personal guarantee burns off? If you're not sure how to do that, call a lawyer. They can help you. It's not that hard. And the sixth and final lesson that you should take away from this is read what you sign. Don't sign something without reading it. As always, if you're enjoying the content, like and subscribe. We'll see you guys next time.